all well know, climate change is not only an issue of global concern, it's a key threat within South Africa. Climate change poses a significant threat to water resources, food security, health, infrastructure, ecosystem services, and biodiversity. Because considering South Africa's high levels of poverty and inequality, these impacts pose critical challenges for human and national development. The film titled The Battle Between Coal and Climate is fascinating in that it clearly captures the tensions and the paradoxes, if I may use the word, often associated with the nature of the problem that climate change poses to development and human rights. More importantly, it creates, I'm talking about the film now, it creates an appropriate context for us to ponder on what must be done to address these tensions. If you permit me, I just want to flag some of the three tensions that I notice while listening over and over again to the interesting film. The first tension I see, which I think crisscrosses different layers of climate governance, and of course of relevance to South Africa, is tension around sovereign and right to development versus a supranational standard expectation. What do I mean by that? This tension pitches a nation's right to self-determination against the global agenda on climate change. We all know that it is within the sovereign right of a nation to use the resources within its boundary to advance its economic interest. And of course, coal in the context of Africa, comes very big in relation to this because South Africa is one of the leading coal producers all over the world. And of course, coal also drives South African economy to a large extent. So talking about the economic value of coal. And of course, it's also necessary for the realization of rights within South African context, because with more money, it means with energy that is efficient comes, rubs on the welfare of human beings within the geographical space of South Africa. But then, the issue of agenda at the global level makes this tension come out even more clearly, because when you look at the agenda at the international level, the agenda at the international level is can be discerned from pillar instruments such as Paris Agreement, UNFCCC, Kyoto Protocol, all point to the need to sort of divert attention from combustion of fossil fuel, of course, which also includes coal, and to refocus the economy at the national level to low carbon and, of course, green economy. So these are phrases that I imagine at that level. So we see on one hand that there's a tension between the right of South Africa, for instance, to use its resources the way it wishes, and its commitment at the international level to the global agenda, which sort of discredit the issue of using coal for our development. And with in the wave of this development, we discover that it is important for us to look at this issue, because coal is also a major driver of anthropogenic emissions worldwide. And of course, this has been showcased in a lot of writings. So the issue, if I may be precise on that, is that the issue is whether South Africa should resist the global wave by persisting in coal investment or ride on the wing of green economy, which is becoming more fashionable in modern times. So there is another tension, the tension around rights, which I think is even more problematic. Excuse me. See, to mine or not to mine, coal pitches interests and rights against one another. For instance, business as usual approach towards coal mining will have environmental, social, and economic impacts. And of course, this will undermine key human rights, including the rights to healthy environment and the right to health. Yet the problem is not solved by merely walking away from coal to alternative energy, because there is a question as to whether transition alternative energy can be just to all stakeholders. The stakeholders, I mean, stakeholders in the coal business, the coal sector, like the state, the investors, because the artisanal miners who only mine for subsistence purposes, and whether such transition can be just for those in this fossil-based sector. Whether transition to alternative energy is sustainable is also one of the questions that fit into this tension. Also, whether such transition will also respect rights of workers who already operate within this existing coal sector. In terms of their job security, it's also a big issue when we talk about this second tension of rights that necessarily emanate from the battle between coal and climate change. Of course, the third section, let me just, I'm not doing well for time, is tension around remedial solution. Remedial solution in terms of appropriate response. How do we respond to it? Do we go to conventional way of public interest litigation, or there are more consensus-driven approach that can help South Africa navigate, of course, Africa also navigate these all these tensions. So I have with me today, interesting panelists who studied speakers and of course discussants who help look into these provocative tensions. And activities experts in their own right, and I feel that their intervention will help us appreciate the depth of the challenge, and of course, also propose appropriate solution to the tension. I want to start by introducing Judge Alessandra Leffehermer. I hope I got the pronunciation right. Alex is a researcher and activist on climate justice. He has his PhD on climate justice and has dedicated a considerable part of his life to working on climate justice through teaching, research, writing, organizing, activism, and of course advocacy. Presently, he works as a South African climate justice campaigner with 350africa.org, and he has served as the secretary of the Climate Justice Coalition, a coalition of South African trade unions, civil society, grassroots, and community-based organizations. Alex has worked extensively around advocacy on climate justice in countries, including the United States and Australia. And we are going to be trusting that Alex will be able to share his thoughts on advocacy, response to key stakeholders in the coal sector who resist the idea that climate change even exists. The climate deniers, those who don't believe it exists, despite the intimidating signs to the contrary. And of course, Alex is also going to be sharing his thoughts on pertinent issues in relation to just transition to a low carbon economy in South Africa. It's going to be looking at some of the ways that environmental activists, lawyers, and others can help to respond to this challenge. The second speaker, which we also have here, is Mariette Liefferink. I hope I got the pronunciation right again, who is a long-standing friend of ELA and a collaboration. It's always in collaboration with ELA. I cannot speak more highly of this inspirational personality. Mariette is an environmental activist. As a matter of fact, there's a brilliant film about activism in response to the harm caused by mining in this area called Juicy Gold. Our work is of particularly value to large urban settlement in industrial areas. Of course, in consequence of his principled service over many years to this cause, she's increasingly been acknowledged and consulted by government and other stakeholders all over, Africa, including the Southern African region. Time will fail me here, but let me just say several times she has successfully dared where angels fear to tread. Mariette is a mentor to many, and she is still making great breakthroughs. Our work and activities have influenced and contributed to a significant number of academic treatises, papers, and books, including rights mobilization in South Africa in the context of acute environmental harm. Mariette, we're going to be trusting the expertise of Mariette to look at current problems with coal mining in South Africa. She's going to be engaging us on some of the environmental, social, economic impacts of coal mining in South Africa. From my experience, right from the field, not just textual, right from the field. She's going to be also engaging us on key legal instruments intended to respond to these impacts. And that's not the only thing Mariette is going to be looking at. She's also going to be engaging us on legal instrument effective based on our experience and research. I mean, instruments that can be used to address these tensions in relation to climate change and coal in South Africa. So I want to, at this juncture, hand you over to Alex for his presentation. Thank you so much. Over to you, Alex.
Thank you very much, Professor Jegede. It's a pleasure to be with you all here. Hopefully you can hear me all right. The audio is clear. Great. And yeah, I think it's really a powerful documentary that we've all watched, and it really does reveal a lot of the tensions at play when it comes to, you know, making the transition to renewable energy. And at the key of it is the question of a just transition. I think hopefully as lawyers, and I'm also trained as a philosopher, obviously defining what is just is part of the challenge, really. And it really is a very contested term, and one that is not often trusted in these spaces. You know, I think there's a lot of union members that are very skeptical of the term, because we've seen historically in many countries that, you know, when transitions happen, there's discussion of justice. When corporations come in, there's discussion of social labor plans, which will take care of communities, which will take care of workers. But in reality, that's often not the case. So I think a big part of our challenge ahead is, how do we build trust, and how do we build a sense of accountability that actually we do make this transition, that workers won't be left behind, that communities won't be left behind. Because we can look at historic examples like the gold mining sector, for example. And there, you know, essentially what happened was we saw a big decline in gold mining in South Africa, and 60,000 people were left unemployed, and there was no meaningful just transition plan. So I think people look around and they see that, and that's why you get the likes of the NUM representatives, the National Union of Mine Workers, who tries to deny climate change, who tries to deny that we need to make the transition, and tries to hold on to what is there in the context of deep unemployment, deep inequality, the deep poverty that pervades South Africa. So unlike countries like Germany, which, you know, are able to mobilize significant resources, billions, to invest in a just transition plan, against the backdrop of a fairly equal, a fairly well-employed society, here in South Africa, it's a much bigger challenge. And so how do we prevent people from falling into the deepening cracks and the deepening inequalities that are here in South Africa? I think that's one of our major challenges, and that speaks to societal, socio-economic transformation, which is in some ways a much bigger question than just transitioning from coal to green energy. It speaks to something much deeper that we owe to our communities, and that we owe to our workers. But I think at the same time, it's a little unfortunate that the NUM representative is denying climate change. He's not, I mean, not all unionists in South Africa certainly are doing that. So we're putting on my hat as secretary of the Climate Justice Coalition. One of our members is the South African Federation of Trade Unions and the National Union of Metal Workers South Africa, NUMSA, one of the biggest union in South Africa, right? And they're very clear that climate change is real, and that we need to move towards, in their positioning, more socially owned renewable energy, that we need a just transition that puts renewable energy not just in sort of the very privatized manner that we've had in South Africa, where historically it has been dominated more by multinationals and private interests. They're calling for a transition to more socially owned renewable energy, you know, where workers own it, where Eskom plays a bigger role in driving our publicly owned renewable energies. And so, you know, the NUM voice in some ways is a bit of an outlier. And it's not to say it's not there, but it's not representative of all union voices. And even if climate change is not real, and, you know, I've spent my life fighting around climate change, but you could take climate change out of the picture and things are still, the case for shifting is still there. The economics of renewable energy is clearly much more favorable than coal. the unreliability of our outdated and unreliable coal power plants is driving a lot of people to recognize the need for renewable energy. The job creation potential is greater. The water, air, and soil pollution of coal are all reasons we need to transition. So you can deny climate change if you like, but there's so many other factors you need to deny if you wanted to avoid that transition. So I think there's a sense in which, that denial actually ends up harming the workers in the long run, because the economics, that transition is happening. So if we give false hope to workers that actually know we can just not do it, and you can understand why, because it is scary to think about that transition, and we know that workers aren't taken care of. So denial in some ways is a perfectly understandable response, but it's not what is going to help in the long run. And I think when we think about what is going to help in the long run, how do we ensure that transformation? I think we face a major political obstacle, because I think we can't be naive to the fact that at the core of the state capture project in South Africa was the coal sector, was Eskom, right? And so this is the heart of corruption. And so it's not just about putting in place policies for a just transition, it's about building the political power needed to hold the state to account. As the documentary said, the Department of Mineral Resources didn't even want to be part of the documentary, and they often just grant permits despite objections, despite, the very important legal processes that they should be following. They kind of just rubber stamp through the whole thing, right? And so in some ways, the law is obviously a very vital process that we still need to use, and we still need to be challenging on that front, but it's a question of much deeper political accountability that we need to deal with, where the Department of Mineral Resources and Energy, because they're now combined, have become somewhat unresponsive to democratic processes and unaccountable. And we see that time and time again, where they don't respond to the most basic of responses. For example, Groundwork, a nonprofit organization operating out of KZN, is suing the Department of Mineral Resources and Energy just to get the reasons why they force new coal into our energy mix, the integrated resource plan. And the Department of Mineral Resources and Energy refuses to even give the reasons why. I mean, you would think it's the most basic form of accountability. What is the reasons behind your decision? Right? And so I think we face that depth of state capture and that depth of unaccountable governance. And so part of what we're trying to do in the climate justice movement, we do work with public interest law firms. We do work with lawyers that are trying to hold accountable. But we're trying to build the political movement that can also try to shift that. And we're very far from that right now. So there's a lot of work to go to build. So I think these are some of the challenges that we face in making this transition just. And that, as we transition the energy sector, there's also a question of a much deeper socio-economic transformation that South Africa needs to make as part of that. And so can this be, we built an economy essentially on the minerals energy complex. It was one of the most unequal economies in the world, and it was also one of the most ecologically devastating economies in the world. And I think that's the twin foundations of exploiting humans and degrading the environment. And that dual exploitation, I think, is what we need to think about in terms of transforming South Africa. And so, I mean, the documentary is about coal and climate, but in a sense, it's a documentary that's also at the core of South Africa's need for deep transformation. And I think if we don't see climate change in that broader sense, if we just see it as this isolated issue, we miss a lot of what the picture is about. And I think that's where we move from a sense of climate change advocacy to climate justice advocacy, which is trying to look at that broader systemic sense of what is climate change is just a symptom of something much deeper. And in South Africa, the deepness of that structural injustice is really profound. And so unless we really look at that, I think we'll only be dealing with a small part of the problem if we think we can just make an easy transition to renewable energy. It's not to say we must transition. That transition, we have to do it because of the climate crisis. We have to do it because of all the harmful impacts of coal. But I think we need to reckon with these deeper questions as we do it. And we need to build a major political and legal force to ensure that we do it against the major resistance we all face and are facing. Maybe I'll leave it there. I don't know if you want me to dive deeper, but hopefully that's a helpful contribution. And thank you for having us, or having me.
Yeah, thank you so much for your extensive and very interesting and brilliant presentation, Alex. And of course, you raised interesting points, which I think will further provoke some comments from those who have heard your wonderful presentation, particularly in relation to seeing climate change within seeing the film within the broader context of equality, in South Africa. Because when you look at the films, when you look at the film, when you recall or when you reflect on the film again, one of the things that is clear is also the issue of poverty, the issue of subsistence, issues that are at the heart of South African rights, particularly to vulnerable populations. Because you also raise the issue which around justice, how just is the transition. And even if we all know that green economy is just a matter of time, is the future. Of course, the present too, in some quarters, how well are we able to, how well are we able to prepare for it and do it in a manner that respect rights of vulnerable population, particularly workers who are in that sector, who may just be jobless, and should they rather just leave without anything, without being properly taken care of. So thank you so much for that. I don't know if we have questions, 1 or 2, 3, before we go to the next presentation. I would like to welcome some questions. I've seen comments here, interesting comments. I can even keep up with the speed of the comments, but if I can just get some 2 or 3 questions by way of raising hands, it will be to make the job much more easier. Thank you. Yes, do we have questions? Let me flip through here and see if there are questions here. You can ask your questions if you have it.
I think we can go straight to Mariette, and while Mariette is speaking, we can consolidate some of these, and everyone can also formulate questions either in writing, or feel free during question time to raise your hand.
Thank you, Melanie. Thank you. Over to you, Mare.
Thank you very much. Thank you for the unmerited and gracious introduction.
Of course, it's merited.
And I just also want to concur with your comments that there is indeed a tension between rights, the tension between the right to development and the right to an environment that is not harmful to health and well-being. I also thank Alex very much for his presentation. And I shall perhaps also in some instances overlap with his statements. Now, as highlighted in the documentary film, there are significant environmental health and socio-economic challenges associated with coal mining, such as Alex also referred to, contamination of surface water sources, soil and groundwater contamination, air pollution, land degradation and loss of productivity, bioaccumulation of metals, loss of biodiversity, impairment of ecosystems, contribution to ozone depletion and global warming, and there are also human health impacts, disrupted and unenriched communities. Notwithstanding the fact that climate change is not a myth, it's an established fact, and notwithstanding South Africa's vision to achieve a zero carbon economy by 2050 through switching from coal to renewables in terms of phase 2 of the National Planning Commission's process to deepen the initial work in Chapter 5 of the National Development Plan, and notwithstanding the Department of Water and Sanitation's proposed actions in terms of its National Water and Sanitation Master Plan to declare strategic water sources areas and critical groundwater recharge areas and aquatic ecosystems as threatened or sensitive as protected areas by 2021, and to promulgate aggressive restrictions within the legislature to restore and protect ecological infrastructure by 2020. I shall continue with these notwithstanding issues, but I just wish to here interpose to explain the objectives of the master plan of the Department of Water and Sanitation. The master plan contains the top priority issues confronting the water and sanitation sector at this time, and includes actions with timeframes to ensure that by 2030 and beyond, South Africa has a sufficient reserve of supply to take it safely into the future and to meet constitutional imperatives, for example, human dignity, equality, and the advancement of human rights and freedoms, including an environment that is not harmful to health or well-being, and to combine that with the National Water Act and the Water Services Act and certain national water and sanitation policy papers. I now continue with the notwithstanding. So notwithstanding the South African Human Rights Commission's directives to the Department of Environmental Affairs, Forestry and Fisheries and the Department of Water and Sanitation to take definite steps to ensure legal protection of our water source areas, and that the Minister of Water and Sanitation restrict or prohibit the grant of water use licenses in water source areas. My organization continues to receive new applications for coal mining, some in sensitive and protected areas. Of particular relevance is the Azer mine, coal mine. The Minister of Mineral Resources granted a mining right for coal mining in the Mabola protected environment, a strategic water source area, and ministerial consent was given under the NEMPA, that is the National Environmental Management Protected Areas Act, by the Environment and Minerals Ministers respectively, to mine commercially in a protected environment. A water use license was granted and an appeal against the authorization was dismissed by the Water Tribunal. These challenges were summarized by the South African Human Rights Commission in its report pursuant to its national hearing in 2016 on the underlying socio-economic challenges of mining-affected communities in South Africa. It found, overall, the mining sector is riddled with challenges related to land, housing, water, the environment, and the absence of sufficient participation mechanisms and access to information. Non-compliance, the failure to monitor compliance, poor enforcement, and a severe lack of coordination amongst especially government stakeholders exacerbate the socio-economic challenges faced by mining-affected communities. The Commission directed the Department of Health, in partnership with the DMRE, that is Department of Mineral Resources and Energy, to commission a study to assess the impact of mining activities on communities' health, particularly respiratory health. I think the documentary did indicate that there are significant challenges in this regard. My organization is unaware whether or not these directives have been enforced, notwithstanding the fact that we were part of the advisory committee of the Commission. The documentary film highlighted certain challenges, all of which arguably undermine the fulfillment of the environmental right enshrined in Section 24 of the Constitution. But before I discuss these problems or challenges, I have to acknowledge that positive duties do exist. For example, Section 19 of the National Water Act deals with the prevention and remediation of pollution. Government Notice 704 of 1999 regulates the use of water for mining and related activities aimed at the protection of water resources. Section 28(1) of the NEMA, National Environmental Management Act, deals with duty of care towards pollution prevention and remediation, and provides for a very broad duty to take reasonable measures to rectify pollution or degradation. Although the term reasonable measures are not defined in the NEMA, the environmental management principles set out in Section 2 of NEMA can assist when determining reasonable measures. In terms of Section 34 of NEMA, a wide pool of persons, directors, in their personal and collective capacity, managers, operators, members of the board, etc., can be held liable. Both the National Water Act and NEMA makes provision for the Department of Water and Sanitation and the DMRE to issue directives to compel illegal mining companies to take specific reasonable measures by a given date. Section 49A, subsection G of NEMA provides that the failure to comply with the directive issued is regarded as an offence in terms of NEMA, and a person convicted of an offence listed in terms of section 49AG is liable to a fine not exceeding 10 million or imprisonment for a period not exceeding 10 years, or both such fine and imprisonment. Both the NEMA and the National Water Act are retrospective. It is therefore no defence to say that the pollution is historic, indirect, or underlying. The responsibility to take reasonable steps remains. I now come back to discuss the challenges in the coal mining industry. The first challenge is the externalization of cost model, which has driven the coal mining industry and which is no longer sustainable, as well as the 100 or more year legacy of coal mining, which makes the apportionment of liability problematic and cumbersome. Coal mining is categorized as a category A mine, that is a mine where pyrite occurs in the mineral deposits, hence the mine is acid producing. Acid mine drainage and related mine water impacts have in the past decade evolved to become a major environmental challenge. While the challenge is limited to the mining sector during operations, it eventually becomes externalized during mining downturn and is especially pertinent post-mining closure, especially if mine closure does not proceed according to regulatory approved recommendations. A&D continues many years after mine closure. It is often externalized to mining affected communities, future generations, and a mute environment. A mine water management policy was drafted by the Department of Water and Sanitation in 2017 to address some of these issues. The policy, however, has not been finalized, so these challenges remain unaddressed. The second challenge is the facilitation of the dereliction of duty. Let me explain. The South African legal regulatory framework enables mining companies to circumvent closure duties. This is as a result of the lack of articulation between the closure requirements in the MPRDA, the Mineral and Petroleum Resources Development Act, and the process for winding up companies as set out in Chapter 14 of the Companies Act of 1973, and the fact that the liquidator is not obligated to apply for a closure certificate when the company itself has failed to do so. The most serious consequences of the winding up procedure is that the company ceases to exist as a legal person. If no person legally exists, these obligations, by extension, cannot be enforced. The Parliamentary Committee on Mineral Resources recognized this gap in legislation, and after its oversight visit of the mining operations of the Mintails Group in 2018, directed the Department of Mineral Resources to identify clearly and specifically the gaps between mining, insolvency, and company law that has led to this ongoing situation where the polluter does not pay. It is the state that ends up paying. The DMR should get specific legal opinion on these complex issues. The committee also directed the DMR to report to the committee in Parliament on what it will do or needs to do differently in future to ensure that this situation does not exist. I'm not aware of any of the implementation of these directives. The Department of Environmental Affairs proposed regulations pertaining to financial provision for the rehabilitation and the remediation of environmental damage caused by mining and prospecting proposed to address this gap. That is, that where liquidation or business rescue proceedings have been initiated, the liquidator or business rescue practitioner of the company will be responsible for implementing the rehabilitation and closure plans and the remediation and management of residual and latent environmental impacts, including ongoing pumping and treatment of polluted or extraneous water. The proposed regulations are being welcomed by us. However, it has not been finalized. The third challenge is an undercapacitated and potentially inhibited law enforcement agency. And that was highlighted in the Unzanzi Environmental versus the BP Southern Africa case. The documentary also highlighted the phenomenon of well-resourced companies selling off marginal mines to smaller companies during the end of the mine's life. That is as part of a closure strategy. The liability for pollution, ecological degradation, the pumping and treatment of extraneous water, such as acid mine drainage, and latent and residual impacts, as well as the obligation to apply for a closure certificate, then rests in the least well-resourced and most precarious corporate entity. The fifth challenge is inadequate financial provisions. The South African Human Rights Commission found in this regard that the Department of Mineral Resources has not taken adequate steps to secure financial provision for rehabilitating damage to the environment and water resources. The financial provision for rehabilitation of the coal fields of Mpumalanga is estimated at 17.5 billion. This provision does not cover the cost to human and environmental health and the social legacy of people employed, supported, and attracted to the mines. Environmental and socio-economic consequences take several decades to take effect. Financial provision for latent and residual impacts is inadequate. And the last challenge I wish to discuss is unregulated artisanal mining. The documentary also covered this aspect. The current socio-economic situation in many parts of South Africa has pushed many people into unregulated artisanal mining, as in the coal fields of Mpumalanga. There is evidence of a direct link between the retrenchment of mine workers and informal mining, or artisanal mining, where former mine workers having the requisite knowledge of not only the process but also of the workings and underground infrastructure of the mines. The informal nature of artisanal and small-scale mining, as well as the non-existent legal protection, make it amenable to illegal dealings, especially in high-value minerals such as diamonds and gold. Artisanal miners are therefore easy victims of organized crime and paramilitary organizations. The Department of Mineral Resources and Energy is currently developing an artisanal and small-scale mining policy. Artisanal mining can play a complementary role to large mining operations. Large-scale miners are to be encouraged to build relationships and partnerships with artisanal miners to assist artisanal miners with building technical capacity, gain access to appropriate technology, and consequently prevent environmental degradation, get access to prospecting and mining areas, and gain access to the market. The lack of business and market knowledge and lack of finance can force artisanal miners to sell to middlemen at low prices, perpetuating their poverty. Artisanal miners are therefore kept in a poverty trap where their operations rarely graduate above subsistence and remain economically and environmentally unsustainable. This is my last comment, and I thank you very much for allowing me to address all these challenges. Thank you.
Thank you so much, Mara. We cannot thank you enough for that interesting presentation, which sort of captures impression of a field person. Or, you spoke around the challenges which are often associated with coal mining. course, you mentioned, you articulated them in particular terms, talking about contamination of surface water causes, air pollution, loss of biodiversity, human health impact, of course, disrupted community life, which are, just so real, in the context of vulnerable populations, not just about their rights, and of course, but the context in which they operate, that is, the biodiversity around them. Of course, you also highlighted challenges which you feel are very important and are undermining the realization of the right to healthy environment as entrenched in Section 24 of the South African Constitution, which is where, that is where you made reference to externalization of cost, legacy of coal mining, and you also touched on, facilitation of dereliction of duty, and you give examples of that within the context of South African regulatory framework, how it hits, how it hits the breach of Section 24 of the Constitution. It's such an harrowing anyway that the Constitution will guarantee a right to a healthy environment in one breath, and there will be this pocket of legislation also existing, which can be actually, used to breach this right in the way and manner they operate. That's quite, ironically and interesting for me. Then you also made reference to other points, which include inadequate financial provision and all that. And you talk about unregulated artisanal mining, which is, I think, is also key. We're looking at the concept of, just transition that Alex was also speaking about the other time when he was referring to broader issue of inequality and poverty in South Africa. So these are I think are each comments that you have made that I think could generate further discussion. So thank you so much once again for your interesting presentation as usual. So I don't know now if there are others who want to say one or two things, or there are questions to be asked. It will be quite interesting to hear our questions and, of course, to engage these all important issues that we have been able to identify. Thank you. I think let me see some more.
Thanks, Ademola. I've been following the questions, and I don't know if Alex, you've picked up on a couple for you that you could start us off, and then we'll go to Mariette.
I think we try to unmute at the same time there. Anyway, I can try to go to a few. I think I saw one about a question of whether the government is implementing sort of retraining or upskilling programs to workers in the coal mining sector. And ideally, that should be the case. I mean, there really should be programs in place. We see that in other parts of the world where there has been social compacts put in place with unions, impacted communities, and government officials all coming together to sit around the table to develop just transition plans, and as part of that to invest significantly in economic diversification in the regions that will be most impacted, to invest in reskilling workers, and that doesn't only have to be limited to renewable energy. I mean, it's a much broader diversification in trying to move workers into new sectors. The government is undergoing currently a national employment vulnerability assessment to try gauge better what that should look like. So there are sort of plans afoot, but they're really dragging their feet on the implementation of just transition policies. And I think part of the dragging the feet on the just transition policies, quite honest, has to do with capture. I mean, it has to do with protecting coal interests. The just transition's there, it helps facilitate the transition, it helps makes it happen, and it helps reduce the resistance from workers if they know that they can actually be, if they can be transitioning. So sort of one of the cynical tactics of a lot of corporations has been to keep their employees dependent on them and to fight against these sorts of policies. And so there's a question of corporate power at the heart of this, where actually there are those that stand to benefit from us not implementing a just transition, who stand to benefit from slowing things down. So I think those dynamics are very much real here in South Africa, and it speaks to the question of political power at the heart of this. I think it speaks again to the need to build a climate justice movement that is very broad and powerful. And I think a big part of that means that we need to look at climate change, but we also need to connect our struggles to the struggles for economic justice, for social justice, for environmental justice. I think only then can we get the requisite level of power, political power, to make the shifts required. And I think this also maybe speaks to those who are in this to think about how can we broaden our analysis and broaden our approach to draw others in to build the sort of requisite political power. So yeah, I think that's one question that I saw come up there. I don't know if there were others that were addressed to me that you'd like me to address, or whether I should maybe hand over to Mariette for a little bit. Melanie?
Yeah, I think let's hear from Mariette as well. I see Mariette, I see there were a few questions for you. I've sent them to you in the chat, but I don't know if you've seen them there.
Yes, I've picked up a few about the retrospective aspect of NEMA being controversial. I would just mention that I do not think it would be equitable or fair or even moral to just hold the last man standing responsible for the environmental damage. Professor Tracy Humby used an analogy. She referred to the party game. I don't know if any of you know the Pass the Parcel party game, where the music plays and then the parcel is passed from one to the other, and in the end the last person gets a gift, but also the smaller parcel. And she used this analogy to describe, or this illustration to describe, that often the last man standing within the coal or gold or whatever mining mineral, they often do get the smaller part of the asset, but they get the biggest part of the environmental liability. I must just mention to you that this duty of care also predates the Mineral and Petroleum Resources Development Act and also the NEMA. If perhaps I can have an opportunity to respond in a written format, I can illustrate that then. There was another question that was asked, whether or why do I state that the financial provisions are inadequate. Now, I can only refer now to what has happened within the goldfields. Within the goldfields, there's only 200 million litres per day of acid mine water, because remember, gold mining and coal mining are both categorized as acid producing mines. Now, in the gold fields, it is estimated that to treat acid mine water, that is 200 million litres per day, will cost in the CAPEX, the capital expenditure, 6.6 billion rand. With regards to the treatment, the OPEX, that is the operational cost, it will cost 990 million rand per annum. That was what was determined by the Department of Water and Sanitation. Remember, acid mine water will continue for many years, sometimes hundreds of years after mine closure. So that is why the calculation should be made whether these mining companies do indeed have sufficient funds to financial provisions to address the long-term treatment of acid mine drainage. I also just want to make a comment. Many communities, that is mining affected communities, are characterized by widespread poverty. They are in need of employment. But in many cases, mines are now opting for mechanized mining. And these mines often require skilled labor or semi-skilled labor. So unfortunately, often these mines create unrealistic expectations of jobs. So when we think about the rights of workers, we must also take into consideration that these workers often, not just by a just transition to a green economy, they may be replaced because of mechanized mining. This is already happening within the gold fields. Thank you.
Aaron, thank you so much for that extensive response to questions. I think Alex also has some response because I can see a range of questions directed to you. Over to you, Alex.
Sure thing. Yeah, there's a few in there that I can address. One speaks to the need to try and convince communities that there are significant benefits for them when it comes to renewable energy. And I think this is an element where we can think carefully about how climate justice must also incorporate racial justice, especially in the South African context, where we see that the coal sector was, as the document pointed out, quite a successful example of BEE. It's rather unfortunate that BEE got pushed into this, what will eventually become a dead-end industry, right? But that's not the successful case story in the renewable energy sector so much. And it is a sector that's perceived to be quite white. It is perceived to be European in its sense. So I think there needs to be a sense in which that transformation occurs. And part of the reason for that perception has to do with, there are some malicious interests that spread bad propaganda in this space, essentially corporate propaganda and PR that tries to malign renewable energy. But part of it is the reality of the industry not being as transformed as it needs to be. And much of the projects being owned by foreign multinationals that are predominantly white. Right? So there's major questions there if we want our communities to really believe that this transition will benefit them and will benefit our workers. There was a question about, is it realistic for us to transition to 59% by 2030? It seems like it's a short time away. And actually, it's, we should be transitioning faster, and we can be transitioning quite a lot faster than that. So the Integrated Resource Plan, which is our electricity blueprint for the country, the Department of Mineral Resources and Energy actually artificially capped how many renewables we could put into our energy mix, despite it being more economic and more job creating if we lifted that cap, right? And so they forced in new coal into the energy mix. And actually, if we were following what was more economically feasible, what would save us more money in terms of our energy costs, we would be pursuing even more renewable energy than that current mix. And of course, if we were following the climate science, we'd be moving a lot faster than that too, because the urgency of the climate crisis suggests, that we shouldn't just be following the narrow economic perspective on what is the least cost when it comes to just thinking about the cost at your electricity bill. There's much deeper societal costs that come with coal that aren't reflected there. So yeah, I think it is realistic to go to 59%, and we should be going much faster. And that's a big part of our push as civil society, is to move much faster than that and to align our renewable energy with what's required to keep warming from going above levels like 1.5 degrees Celsius, which was agreed to under the Paris Climate Agreement, which would require us to move quite a bit faster than that in terms of what South Africa's fair share would be. And then the last one I'll just quickly touch on is this question around Eskom and whether they should be part of it or whether we should break up the monopoly. And I think there is a sense in which allowing more players to come in could be helpful. But we must also not forget that Eskom has access to a lot of land, a lot of power stations, right? And so Eskom could be a major player in this space because they can invest. In fact, there's a lot of discussions right now of Eskom implementing a green financing package so that they can repurpose a lot of their old coal power stations to move towards renewable energy. But there needs to be a lot more pressure on Eskom to ensure that happens at the right speed. So we actually did develop a Green New Eskom campaign, which is all around that. So if you're interested, you could find out more just by googling Green New Eskom if you'd like. So I'll leave it there. I don't want to talk too long. Thanks, everyone.
Thank you so much, Alex, for that precise and intelligent response to some of the questions that are raised there. I'm trying to figure out. I think I see at some point, a question in relation to litigation. I sort of I've lost touch of it. Then I don't know if Milani, do you see such a question there? I mean, somebody was asking about a particular case.
What happens when the DMR fails to issue the directives that it's empowered to issue, directed at Mariette? So Mariette mentioned that in terms of NEMA, the Department of Mineral Resources does have the power to hold mines to account during the life of the mine, but doesn't always exercise this power. And then what is it that organizations like yourself do in those situations to try and come to the assistance of the communities that are affected? And what has the success been like, or the experience been like in those struggles?
Can I respond to that question? In our case, it was a 14-year battle. The DMR did issue directives against the Mintaus group. However, these directives were not adhered to, and then there was no enforcement of the non-compliance with the directives. So with the assistance of the Legal Resource Center, we have then instituted now legal proceedings against inter alia, the Minister of Mineral Resources, the regional manager, in fact a wide pool of organs of state. There are 36 respondents, but our main focus is on the organs of state, the ministers, in which we ask them to exercise their mandate and to hold the directors of Mintaus responsible for the environmental degradation and the pollution. Just incidentally, the Department of Mineral Resources allowed the Mintaus Group, an Australian mining company, to operate without an approved mining right, without an approved environmental management program report, and with a financial shortfall. The rehabilitation fund had a shortfall of 461 million rand. So there was obviously negligence on the part of the organs of state and the Department of Mineral Resources, and that is common cause. In fact, our court case is unopposed. Our first hearing was on the 12th of August, and the learned judge then asked us, he granted us a preferential date to again appear in court, but he asked us just to summarize what we want from the respondents, especially the organs of state, to be very specific what we want from them. Not only to state we want them to make safe the areas or to hold the directors accountable, but to be more specific. And he also asked us to ask an expert report on the impact to the communities and to the environment. Although I must just mention here, and I say it very respectfully, there are an abundance of reports, academic and government reports on the impacts of the communities. I just want to mention Adelaide, also in on the chat group, mentioned that the example of Leffehermer, and here I also want to mention that we must remember, even not just in gold mining, also in coal mining, although we have an abundance of coal, any mineral or metal the mining of it is unsustainable because it depletes a non-renewable resource. So in time, whether it's now or in 10 or 100 years of time, there definitely will be a depletion of the resource. And that is why we have to also take into consideration, in terms of Section 24 of the Constitution, not just the rights of the current communities, but also of future generations. In the case of Leffehermer, for example, it left an environmental liability of 891 million rand. At the moment, the communities are carrying the cost of that. Thank you.
Sorry, I think we may have lost Ademola, but hopefully he'll join us again. I see that JD has a question, so I'll give him a chance, and then I'll give Alex one last chance to answer a few of the questions that came in, and then we can also go back to Mariette briefly, and then wrap up. But over to you, JD.
Yes, hi, good evening, everybody. This is now a bit unfortunate that we lost Prof. Jegede, because the question was kind of aimed at him, but then hopefully, Dr. Makot, you can maybe just fill in for him. Yeah, it's a bit of a question that refers back to the work that we did on transformative constitutionalism. Can't there an argument then be made on the fact that we see a lot of companies are getting away with a lot of environmental degradation and kind of getting just a light slap on the wrist a lot of times, is because a lot of time legislation regarding environmental protections, it lacks a certain punitive element. It's not punitive enough for example, for a corporation to go, hold on a minute, maybe, you know, degrading the environment and being the cause of serious environmental fallout, it's still cost effective. It doesn't cut into our bottom line. It doesn't really matter. So shouldn't specifically legislation, then a constitution in line with transformative constitutionalism, and then a broader international conventions and framework should be set up to ensure that that law, as we understand it, takes a bit more of a hard stance on environmental degradation and kind of just keeps companies from basically doing really whatever they want in terms of how much we can pollute the environment, et cetera, which will also allow for a more like, well, if it isn't profitable for a company to use environmental fallout, then it becomes a lot easier for new markets to emerge where green energy will become more profitable and more enticing for market entities to really just latch onto more.
Thanks for that, JD. I think the only thing I can comment on that is that the litigation we have seen where companies have been required to pay damages, or mining companies specifically, is where the mining companies have caused the miners to suffer silicosis. And so we've had successful class actions that have led to mining companies paying out massive settlements to individuals for causing silicosis. And silicosis, obviously a disease that arises from bad environmental conditions in mines. And one of the interesting connections, racial injustice, climate injustice, environmental injustice, is that the black miners were not given the necessary safety equipment, and the white miners were. So the number of black miners who suffered from the disease and died from it was very, very much higher than the white miners who were potentially exposed. And that also was an illustration of how the mining company knew very well what was required, its historic cause of silicosis. They knew what was required because they gave the necessary safety equipment to some and not to others. So that's one of the big cases. But what we haven't seen is claims for damages in the situations like Leffehermer and Mintails. And I think there is space for that. And I think you guys, as the next generation of environmental lawyers, need to be thinking about the right kinds of class actions to be bringing. Then I think there's a couple of questions for Alex. And so I'll give one last round. We'll wrap up in the next few minutes for Alex to respond, and then any closing remarks from Mariette, and then we'll sign off for the evening.
Thanks, Melanie. I'll just quickly address the couple there. One is around labor unions and the need to get them on board the transition to green energy and what work's been done there. So back in 2010, there was a pretty vibrant 1 million climate jobs program that was endorsed by a lot of major trade unions, was driven by many of them, in fact. And you know, that initiative had pretty significant buy-in. And so there was this moment where there was major energy from trade unions, from civil society coming together, demanding more socially owned renewable energy and transformation along climate justice lines. But then the Zuma years kind of got in the way, in a sense, and a lot of the politics around that and the state capture and so on drove stake right through the heart of a lot of those efforts. And so currently, I think where we are is trying to pick up those pieces again. But there are trade unions like SAFTU, which broke away from COSATU through part of those divisions, that are leaning quite progressively into climate justice spaces in pretty radical ways that, you know, maybe some more centrist or right-leaning political folks may not be so comfortable with, but they are taking the climate crisis seriously through their own ideological lenses. And so there's a question there, I think, for us in terms of how do we take the climate crisis seriously and work with those different ideological frames and different visions of what climate transformation requires. But there is a lot of work that needs to be done, building support and bottom-up understanding from workers. Because if you do surveys around, like, do you know what the just transition means? A lot of workers have like very little idea around that. And I think that also speaks to the question that Ale raised about, like, using European jargon in ways that alienates people. You know, there's not major understanding around climate change either. There's a lot of just a lack of education around these issues in many of these spaces. And I think South Africanizing it and localizing that discourse is vital. So if it can be seen through the lens of Ubuntu, and I know that there's groups like Earthlife Africa, for instance, that do a lot of local engagements and try to translate this sort of work into understandable concepts and understandable moral framings like Ubuntu too. So there's work being done on that front, but I think we've got a long way to go, and not only in translating these concepts, but also just more broadly educating and mobilizing from the bottom up in both unions and mining impacted communities. And that's a lot of the work that we're trying to do, but we do have a long way to go indeed. So maybe I'll just leave it there because I know we're running a little over time. And thanks again for having me.
Mariette, over to you for some closing remarks.
Yes, I will close off with just responses to two questions I may have overlooked. Catherine asked about whether a liquidator can be held for breach of fiduciary duties if a mine is liquidated. At the moment, we need perhaps amendments to our financial regulations. That is the intent of these proposed regulations that have been published, the draft in 2019, to also hold liquidators responsible for rehabilitation and closure. However, I may mention in the case of Mintails, we are calling on the court to assist us to effect the deregistration of directors because of their dereliction of fiduciary duties, because that was clearly stated in the Business Rescue Practitioners Report and also in the liquidation application. So there was a prima facie evidence of failure to fulfill their fiduciary duties. Then there was also a question regarding to the panel regarding illegal mining by local residents. What should be the appropriate resolution or response? And I think most of the NGOs, we've had recently prior consultations with the Department of Mineral Resources regarding the legalization of artisanal miners, and we are all agreed that that is the way to go. However, we cannot allow for unsafe mining practices and human rights violations within the artisanal mining, such as the use of children and women in unsafe conditions, and also the use of mercury, as in the case of the gold mining. But this is on the cards. The Department of Mineral Resources is in the process now of drafting an artisanal and small mining a policy. And I think that will allow then for local residents to be legally allowed to mine.